Jennifer, working with Deja Naranza, and this is our presentation on Citizens United versus the FEC. Okay, so for background, in 2008, a nonprofit corporation called Citizens United released a film about candidate Hillary Clinton and the Democratic Party's 2008 presidential primary election. They wanted to pay cable companies to make the film available for free through video on demand, and they wanted to advertise the film in 3 specially produced commercials within 30 days of the primary election. The film was very critical of Hillary Clinton, and Citizens United feared that the film was covered by the Federal Election Campaign Act, FECA, which added limits to corporate contributions for candidates. The FECA also led to the creation of the Federal Election Commission, FEC, and they're in charge of limiting campaign spending. Now, the Bipartisan Campaign Reform Act, the BCRA, and also known as the McCain-Feingold Act, expanded the FEC limits on contributions by banning and restricting corporations from financing issue-based advertising on behalf of candidates. These are also known as electioneering communications. Citizens United anticipated that their movie could be considered electioneering communications, so they challenged the BCRA before the movie even released. They said that the BCRA ban was unconstitutional because, for one, the film didn't fit the law's definition of electioneering, and 2, that it violated the First Amendment protections of free speech. So, Citizens United sought an injunction in the district court in D.C. The court denied the injunction, and the Supreme Court issued a writ of certiorari. So there are 3 questions that one could ask about this case. The first one being if the BCRA ban on corporate and union expenditures is constitutional, because Citizens United said it violated their free speech. Another question being what can be done about the 2 court cases, Austin versus the Michigan Chamber of Commerce and McConnell versus the FEC, which are 2 similar cases to Citizens versus the FEC that happened earlier. And these cases will be elaborated on in later slides, but they had the potential to impact the decision of Citizens United versus the FEC. And lastly, the most important question, do corporations have a right to speak independently of campaigns and to use their general treasury funds to produce political speech? This is basically going back to the BCRA ban and its constitutionality.
So what could have happened? SCOTUS could have ruled that corporations are basically businesses and not human beings with rights, and that they can't fund political campaigns. I'm honestly not sure how they could have argued that, but I'm almost positive that that was the dissenting opinion for this case. SCOTUS could have also implemented stare decisis, which, if you guys recall, is when the court allows for previous decisions to stand. This would have allowed for Citizens United versus FEC to pass in favor of Citizens United because of past court cases like Austin versus Michigan State Chamber of Commerce and McConnell versus the FEC, which will be talked about later in the video. So the applicable law for this case would be the First Amendment, specifically the freedom of speech. And the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. And it relates to this case because SCOTUS was trying to limit how much corporations could influence political campaigns and therefore kind of limiting their freedom of speech. The ultimate decision for this case was that SCOTUS ruled that by opposing this case, they would violate the First Amendment. And the Citizens United case extended the First Amendment right to allow corporations to make independent expenditures. And independent expenditures are when a company or a group directly advocate for a political nominee. So, for example, if Publix were to ask their customers to vote for Biden, or if Amazon asked their customers to vote for Trump, then that would be considered an independent expenditure. Going back to the slide with our constitutional questions, the answer to the first question would be that the ban was unconstitutional because it violated the First Amendment, specifically the freedom of speech. For the second question, the answer would be they should be overturned because they contradicted the Citizens United versus FEC case. And for the third question, the answer would be yes, because it would be unconstitutional if corporations weren't able to express their opinions.
Section 441B of the FECA prohibits corporations from using general treasury funds for political use, but court justices found that when applied to Hillary the movie, the statute is unconstitutional, as it directly violates freedom of speech. In the majority opinion, which was written by Anthony M. Kennedy, the court reasoned that limits on an independent corporation's expenditures in electioneering is a violation of the First Amendment right to freedom of speech. The justices who dissented maintained that corporations are not members of society and that their spending during elections should be monitored.
So there are a couple impacts that came out of Citizens United versus the FEC. One being that the Supreme Court overturned some previous election spending restrictions. So previously the court had upheld those restrictions, basically arguing that the government had a role in preventing corruption. But in Citizens United's case, the majority of the justices held that independent political spending didn't provide a substantial threat of corruption, given that it wasn't coordinated with the candidate's campaign. Citizens United versus the FEC is also said to have led to the creation of super political action committees, super PACs for short, which empower the wealthiest donors. So, political action committees raise and spend money for campaigns that support or oppose political candidates or legislation. Regular political action committees have contribution limits to what they can give to candidates, but super political action committees aren't bound by any spending limits, and that's because of a previous court case that applied their logic from Citizens United versus the FEC, saying that outside groups can accept unlimited contributions as long as they don't give directly to candidates. And the case also just basically solidified that corporations have free speech rights.
In the first case, the Michigan Chamber of Commerce, a nonprofit corporation, challenged the Michigan Campaign Finance Act of 1979, which restricted corporations from spending money from general treasuries for political purposes. The Michigan Chamber of Commerce argued that this statute was a violation of their First Amendment rights. The court majority decided that this limitation was not violating any amendments and that maintaining it would prevent corruption. The next case, McConnell versus FEC, was brought to court by groups and individuals like the California Democratic Party, the National Rifle Association, and U.S. Senator Mitch McConnell, from whom the case gets its name. They all believed the FEC's limitation of political spending violated their First Amendment rights. Once again, the majority decided that this statute was not in violation of the First Amendment. In Citizens United, both cases were overruled.
So for a little way to remember our court case, we came up with a little play on words, and we said corporations use funds for elections, which is just using the first letter of each word in the name of the in the court case. And we also made a little meme which says Citizens United explaining to the FEC why they should be able to use unlimited funds for campaigns, and then the FEC saying, no, but actually yes, because we can't go against the Constitution. So yeah, that is it. Thank you for watching our presentation.